when the kid is participating in the work. So if the kid is in the office watching the envelopes being stuffed and the kid participates in stuffing the envelope, the intent of the child labor law, of course, was to protect the child, protect the minor. And I know that we're all on the same page. The other thing I wanted to mention briefly, whereas we had an excellent presentation on statistics and particularly how to find one's way around the website to utilize all that very valuable data, I want to interface with a tad bit of anecdotal information as to labor market realities. We in labor standards don't generally see the students that you folks have all set up and provided programs, because you've done a good job and you know what you're doing and you've educated the employer, and the employer is honest, has integrity, and between you and the employer, they made it their business to find out what's legal and what's not legal. So we don't see your kids for the most part. In my 20 years, I've seen your kids maybe 3 times, 3 different kids. And the paperwork was either there or we were able to confirm with the school that it was part of a legitimate program. I don't know about a school program that has a kid working at McDonald's at 1 o'clock in the afternoon, because the kid could have done that without the school program, but that's an editorial comment. It doesn't belong. Our areas of concern in labor standards, we all know kids are working in food service all over the place, and we know we can probably walk into any food service establishment with teenagers and find child labor law violations. So that sort of goes without further discussion. And kids, of course, are in retail. Those areas, that umbrella includes that we find kids working in nursing homes, bowling alleys, theaters, cell phone stores in malls, kiosks in malls, convenience stores all over the place. The convenience store operators who are not active and involved and well-known in the community and always trying to do the right thing in the right way, the other convenience stores, we find a lot of labor violations for all employees, generally overtime and meal period violations. The particular areas of concern for safety that we encounter are haunted hayrides and corn mazes, and haunted houses. And what we find in particular is that those employers don't generally hire teenagers. It's kind of a one-shot deal for a few weeks, and frankly, they don't know what they're doing as far as child labor laws and regular labor laws. So we find kids not paid at all, paid less than minimum wage, working illegal hours, and of greatest concern, working with pyrotechnics. Also at amusement parks, there was a Batman show at Six Flags in the Buffalo area many years ago. The kid in his senior year was missing school, working during the school day on a farm work permit, on stage, and if you know Batman comics and cartoons, bang, boom, zim, boom, boom, all over the place. So they had what they call ground fireworks inside the building that go kaboom, and the timing was off, and the kid basically lost his face. So he didn't graduate from high school because he was absent during May, and he was getting $70 a show. Would you skip school for $70 to be a star in a show? And you're 17? I can see doing that. Anyways, the pyrotechnics that go hand in hand with some of these really exciting haunted hayrides and stuff. It's a fearsome thing. The cell phone stores, kiosks, convenience stores, owned by individuals who believe that they understand how to own and operate a business, particularly may not understand New York State or United States labor laws and go about it in the way that they may have gone about it in the culture that they came from. Minimum wage and hours violations, record-keeping violations, meal period violations, and particularly teenagers looking for jobs in the mall. So that's all I wanted to present to you. I'll be available for questions at the leisure of our facilitator here.
Yeah, just a quick question. I have a young student, a male student, who asked me just last week that, you know, he had his shift, he knew when he was supposed to be there, and there were three other teens there, and they waited outside the facility for more than an hour, and the boss never showed up to open the facility. And his question to me was, should we get paid?
If it was a restaurant or hotel, they're due 3 hours at New York State minimum wage, or the number of hours in their regularly scheduled shift, whichever is less. So if they were supposed to have worked 2 hours, they're due 2 hours at minimum wage. If they're supposed to work 3 or more, they're due 3 at minimum wage. If it was not a hotel or restaurant, if it was retail or something else, then they're due 4 hours at New York State minimum wage.
Okay, so that's a restaurant.
And we call that call-in pay. If you were to look in the labor law or to search it, it's call-in pay. If you're called or scheduled or otherwise notified to be at work, then you got to get some money for your time and effort.
Thank you.
Somebody else?
I have a question, and it's something that we dealt with back in, I can't recall the fellow's name, but he was the supervisor of child labor in Buffalo, and he's since retired.
Just who you mean, can't
Yeah.
think of his name.
I can't think of his name either. It's with regard to students who are working in hazardous type occupations, i.e. construction, I think that's the best one to use, carpentry. And it's on the bottom of page 15, and it says, these prohibitions do not apply to minors 16 to 18 who have completed training as a student learner or trainee in on-the-job training program, or has completed a training program given by a public school or nonprofit institution, which includes safety instruction approved by the Commissioner of Labor. And again, for several years, we have tried to track down what is that safety instruction approved by the Commissioner of Labor, and or how do you make that happen, you know, within your school? Is there a prescribed safety program that you guys are aware of, or if not, where
Labor standards is not aware of it. Do you have an answer to that question?
Yeah, I'm an ag teacher. We go to the National FFA Convention, and this past year I was at one of the workshops called Career Safe online, and you can get an OSHA certificate for 10 hours, for $25. And this year I'm requiring my students for my woodworking class to take that. It's all online, and you can do it in a certain amount of period of
What's
time.
it called?
Career Safe.
Are we familiar with that?
Yes.
Okay.
Yes.
I think we have an answer.
Do you know if that's approved by the Commissioner of Labor? Yes.
Is it part of this labor program?
No, it's not part of, it's run through OSHA, it's OSHA training, so yes, it is. It's a federal program, so
So
it
do
would
we
be.
have anything in writing that says the Commissioner of Labor approves that? You know,
It's an OSHA program, so any program under OSHA
It's a
is,
federal government
yeah,
program.
it's approved.
Well, there's a piece of this where I'm still seeing a question. OSHA is federal, and we are from the state.
We have both in the state. We have
we're
fed-
covered.
We have federal and private sector,
Yeah,
and for government employees, we have the New York State
right.
PESH, which follows the
Follows the
regulations.
OSHA standard.
But these are not New York State government employees covered by PESH.
What? What she's talking about is not government employees. It's the
Right.
OSHA
no,
government.
student learners who are an exception to the law, an exception to the rule.
So what I'm wondering, or what I'm wishing we could assure the audience, is that an OSHA-issued certificate would be accepted by the New York State Commissioner of Labor. My guess is that, yeah, but where's the documentation, where's the
Exactly,
verification?
that's what I'm saying, is there's something from the Commissioner of Labor, even though this has been in this book for, since I've had this job.
I would wish that someone from this organization would send a letter to the Commissioner of Labor referencing this book, referencing the OSHA program, and get it in writing.
And I have one other question that's unrelated to that, it's about uniforms.
Good.
And I have students who are working at a local car wash that's a chain, and they're explaining to me that they get a uniform allowance in their paycheck, but then it's taken back out. So I guess if an organization is requiring that the kids wear a uniform that says, XYZ car wash, do they have to provide them to the kids, and do they have to launder them for the kids?
A required uniform, not a dress code, but a particular item of clothing specific to that business, such as it's got the business's logo, has to be provided free. Or if the worker is told to go buy it, then they have to be reimbursed for it.
Yes.
To the extent that it depresses minimum wage. And the employer either has to launder that uniform themselves or provide enough uniforms to cover the shifts, so that the worker doesn't have to wash their uniform every day at home. If the worker has to wash the uniform every day at home and only has one for, let's say, 3 or 4 shifts, then in addition to New York State minimum wage, the worker is to get a very small amount of weekly uniform allowance, which is extra money. The fact that the worker is seeing it in the paycheck and then back out of the paycheck, that would work for tips, because the worker already has the tips. So I think in your case, we need to look a little more closely and do the arithmetic and figure out what's happening here.
But if it does not put them below minimum wage, then the employer can require that the student pay for it.
In a car wash, yes. Under the hospitality wage order, which is restaurants and hotels, there's a handful of exceptions that I can't quote exactly right now. Somebody here had a question, and then I'll sit down.
Well, this was about the OSHA training. I think we really have to be really careful, because the fact that a student passes an OSHA 10 is great, but the associated training to go on a construction site to use multiple power tools that's given in apprentice programs, pre-apprentice programs, and CTE programs is way beyond OSHA 10. So a kid passes OSHA 10, and then you put them on a job site and say, okay, run that tabletop, and they never have before. And the employer or the business may not say, well, it's my responsibility to train them, because they came with safety training, and the next thing you know, we're looking for fingers. So whatever that says in there, I know what it says, but I think it's got to be training that's way beyond just an OSHA 10 or an OSHA 30. It's got to be really, really specific to the trade that they're going to.
I would say that in so many words, if you provided a safety training program or whatever to prepare the kid to do what you're going to have him do, I would send a letter to the Commissioner of Labor saying, this is the training we provided. Do you approve this training for this job? We change commissioners as often as we change governors. I mean, it's a fact, it's an appointed position. Each commissioner is like new to all this stuff, and they only know what we tell them, basically. And in my 20 years, I have not ever seen any credentials or rules or references to what you're asking, and it's an excellent question. I think you all need to know the answer, and the Department of Labor needs to know the answer, because we're the people who would issue the violation against the employer, and if that kid gets hurt at work, workers' comp sends the referrals to labor standards to determine whether the kid was working legally. All the referrals I've seen so far are not quite what the program was set up for. We get a referral that 6 months ago a kid a kid served a cup of coffee and got a blister because the hot water splashed. Well, that's gonna happen, but as far as, let's say, somebody getting really injured and the question of the safety training, and then we can't verify that it was approved by the New York State Commissioner of Labor, then we're all wishing that today's conversation resulted in something tangible.
Can I answer a piece of this?
Please.
Because we're going to talk next about workplace resources. The employer is always responsible for the training. So if 10-hour training is done, it's only considered awareness training. It can never replace the training that is required by any employer to do. Just because of what Mark said, your 6 topics could not include what he's doing. So if they take the 10-hour, it became a big deal here in New York State because the construction industry said to give them bigger preferences for jobs, not bigger preferences, but got a bill passed saying with a 10-hour construction, we'll only give contracts to people who have been trained with 10-hour construction, which would be done by the employers. So it's taken off to be like the thing to do is the 10-hour. It's often not specific to the problems that people are dealing with. So if you do it, it's always extra health and safety training, but it is never going to replace for an employer their responsibility to train that worker. So if the employers are asking you, saying, do they have the training, you say yes, but you're still going to train them on their hazards, right?
But
Because it doesn't replace it, it
I
can't.
think the point is if the student is 16 or 17,
Very problematic to be doing things where the laws say not to be done under. So groups that have looked at that, that's been an argument of ours. We've said, we don't really even believe they should be given the 10-hour training because the law says only in very limited circumstances and with certain supervision are they doing this, and that's not part of the ocean training modules. So it's a very tricky thing to have the 10-hour, it's nice to have, and then groups started to work on having a team 10-hour training, but it's very hard to do in construction. And that's
Okay, thank you
another
very
one.
much. You know what, Beth is gonna be here the rest of the day, right? Or
Just tell them.
until noon?
Just one quick
Sure,
question,
real quick.
sorry.
Okay.
Great information. We're here to try to do due diligence. Just a quick question. So something comes up, questions like these. That number is a good resource for us to be able to find out questions like
Yes,
this?
call the number on the back of the book and tell them you have a child labor question. And you'll be routed to the person who's going to answer it.
Okay, thank you very much. As I said, Beth, thank you very much for
Thank you.
participating today. For her, she will be here for a little bit longer, but in the interest of time, since we only have about 5 minutes left and 3 more people to go, we'll try to move on. So, Ed, you ready to face the crowd?
It's not kidding about changing commissioners. They actually have a room at Building 12 that's a conference room. And they have all the commissioners' past pictures on the wall. Those of us who go there, we call it the Dead Commissioners Conference. Now, I understand I missed a lot of fun last night talking about internships and unpaid internships here. How many of you took place in that conversation? Took part in that conversation?
Oh, everybody did.
Glad I missed it. Actually, I was asked to as part of my presentation, asked to look into internships, unpaid internships, and give you the clear facts and tell you exactly how it's going to be. I have 2 court cases in front of me that address that particular subject. And after you hear them, you're not going to know any more now than you do now. But back in, I'll tell you, back in 1993, this one court case has come, okay? And it actually went to the appellate division. Because the intern worked for a hospital as a physical therapist. And to get her degree, she had to do 6 months of field training with no wages. And they had an internship agreement. And it says you're not an employee. And you're not entitled to anything as an employee. She got hurt. and she filed a case trying to get workers' compensation, and she was denied by workers' compensation. So she took her case to the courts and went to the appellate division. And the appellate division turned around and ruled, wait a minute, all the criteria of what this girl did met the criteria of being an employee. She was picked by the hospital to be the intern. They had control over choosing who they wanted. They also had the right to fire her if they wanted to, replace her. And they had all kinds of retained control over what she did on the job, what she actually could do and what she did on the job and the job assignments. So the courts ruled that the plaintiff's training was a thing of value. They took the educational knowledge that this woman was receiving as equal to wages.
Compensation. Yep.
And by doing that, they said everything else that went along with what she did in the assignments and them having the right to fire her and hiring her, she was an employee, and she got granted workers' compensation. Of course, that was 1993, and the appellate division did that. Well, the next case came along not too long ago, and I know every one of the commissioners that sat on this case. There happen to be friends of mine that I don't agree with all the time, but they're friends of mine. They have another case. The person was doing rotations at another hospital as a student intern. And the board found there was no employee-employer relationship between them because it was a medical student that had their own insurance, medical insurance, from the university. Now, all universities, I guess, provide health insurance. And this is what the board was looking at. And they said this person was there as an internship and had to do that internship in order to become a doctor. So doing rotations, it said the person was not even giving a badge that said it was an employee or a volunteer. The badge said student. They also said that the knowledge they were getting was paid for through the tuition they were paying to the school. So that was part of the educational program. And they were assigned to a team supervised by a supervisor at the hospital and resident interns. And the activities that they did was to further their education and to meet their structural goal in getting a degree as a doctor. So they turned this person down, rejected their right. They said there's no employee relationship here, and they threw the case out. The person was not entitled to workers' compensation. 93, they valued the education as wages. Yes?
What year was this case?
This was 2010. I understand that.
For their degree, there's a requirement in order to become professionals. Our students, our high school kids are going out for a week, 2 hours a day, and stuff like that.
I also understand that. Unfortunately, those cases has not risen to this high of decisions that we're looking for.
Where does workers' comp stand on that? That's really kind of what our
I can
question
hear.
is.
I can't hear you.
What's your position on the coverage?
What is the workers' comp?
Position is quite simple. As far as I'm concerned, if they're receiving as high school kids or whatever students, they're receiving a wage, they're covered by workers' compensation. If they're not receiving a wage and they're receiving some other type of benefit, I don't care what the benefit is, as long as it can be related to some kind of wage, or I don't care if it's food, lodging, whatever. I would, in every instance, I would file the claim. You're not going to make this decision on whether they're going to get it. As a teacher, you can't make that decision. As the employer, they can't make that decision. As the student, they can't make that decision. The only one who can make that decision are the judges at the Workers' Compensation Board. And unless you file the case, you're not going to get that decision rendered to you. Yes?
What we are all trying to find out is before we place a kid for 2 days, for 2 hours a day at a location where they're just gonna, maybe help out a little bit there, does that company have to carry that child under workers' compensation? It's not paid, they're not getting free food, they're not getting clothing, they're not getting anything. Do they have to be covered under that company's workers' compensation?
The way this court decision reads right now, no.
Thank you. That's all I wanted.
But I would check. Every day is a change. I would have them file a case. Yes. Yes. Hold on, I can't hear them. Go ahead.
The first case you said they did win the award.
Yes, they did.
The second case, the newer one, they did not.
They got turned down, right.
So there's this conflicting, so this one hasn't gone up to the appellate.
Every
Has this
case.
one gone up through the appellate, through the appeal system yet?
No, it hasn't. And I'm not, it doesn't say it's going there. It's not, hasn't been filed to go to appeal.
Okay.
The case is done. The case is a decision. And the person who got turned down did not challenge that decision. In workers' compensation, when a judge makes a decision,
the manual,
you have 30 days, either side, if you disagree with the decision, to appeal the case. And this particular case where they got turned down, appealed, and the appellate, our commissioners ruled against them. That was the first step of the appeal. They could have then appealed to full board review and the appellate division. They did not. They accepted this answer, and that was it. Yes. Wait a minute, hold on.
What do we say to a business next week when they say, is this unpaid intern, a job shadow student, covered under my BOCES workers' comp?
I don't have a BOCES workers' comp.
They will not, like hospitals, cover them under their workers' comp. And I don't have workers' comp.
Cover the student under your BOCES.
No, we can't.
They're not your employee.
They're not employees.
They're not your employee.
So what do we say to that employer who knows, that business, who knows as much as we do about workers' comp?
What you say to them is, it's a gray area. And if they get hurt, it depends on what the employer had them doing. They could be doing something that they shouldn't have been doing. It wasn't part of your program anyway. And then they're going to be responsible for taking care of it if they get hurt. But is there any black and white? No, there isn't. This is a gray area when it comes to volunteers and it comes to unpaid interns. Do we need laws to kind of broaden this and lay it out for us? Absolutely. Yes.
Mr. Carbone from the Workers' Compensation Board and I have been friends because I've
Steve and I are very good friends.
Right. And he has given me conflicting information with what you're giving me. What he has told me is that if a student if a student is unpaid and at a job site, they are considered an employee because they are getting some kind of knowledge.
Educational compensation.
Under the decision of 93, that's exactly what the appellate division said.
Yes.
Under the decision of 2010, the board said something else.
Okay, and then he also stated to me that if it's a municipality or a governmental agency, in those cases, we do not have to collect workers' compensation because they are insured. We know that they're insured and we
They're self-insured.
They're self-insured, so we don't have to worry about that. So this past year, because he presented to us last year, I went on what he told us and changed our whole process on placing interns. And I will not place a student unless I get information that there's workers' compensation and our mentors know that they're being covered under that. So now I'm really confused, to be honest with you. And
If the employer has other employees, he has to carry workers' compensation.
Correct. I
Okay?
understand that.
Is your student going to be covered necessarily if they get hurt? I can't answer that. They're going to have to file the case and let a judge make that decision. I
But
can't
if I
predict
place
the
a
future.
student in a location that does not have workers' compensation, say for example, someone's sole proprietor, one-man shop,
Right.
and I place a student there, there is no workers' compensation. If the student gets hurt, now who's liable?
Student can still file a workers' compensation claim,
No matter what.
no matter what, because we have something called the uninsured employers fund. That would basically, if he was said they had to have workers' comp, it would cover that student, and then we would go after the employer for not having insurance.
Right, so then we're.
Because we would consider, if that was the case, and that student got hurt, then the board said, yes, you're entitled to workers' compensation, then we would be considering that student as an employee. And being that one-person shop now became two, and you gotta carry workers'
Right,
compensation.
so if we did that, then we would be doing something wrong by putting that employer at risk in case that student got hurt. They would be liable and they could be fined or God knows what could happen, correct?
Possibility,
Okay.
yes. Yes.
I've had 4 businesses, not want to take students unless there's workers' comp provided by BOCES. I have contracts here that they are considering students as independent contractors. The contractor is an independent contractor. The hospital has no responsibility for providing workers' compensation or other employee benefits to the employees or agents. The contractor shall be solely liable for its own debts, obligations, acts, and omissions. Now, I have practical nurse students that are required to do time in acute care settings, and I have hospitals and AHRC that will not, and they want to see the certificate of workers' comp.
Understand something. There are 10 criteria you have to meet to be an independent contractor under workers' compensation. If that employer doesn't meet those 10, then those people are not workers' compensation. The Department of Labor also has the criteria for independent workers, and it's different than ours. The federal government has it. It's different than ours. Our 10 are the only ones that we recognize.
So should the director sign this saying, okay, we can't provide a certificate?
No, because they're not, basically they're not independent contractors.
So then we can't utilize.
Who's going to control their work? Who's going to tell them what time to show up? Who gets a benefit out of it? The employer? Well, guess what? So does the student, but the employer does too, by them doing work, right?
Absolutely.
They're not going to meet the criteria of being independent contractors, yes.
Was it 2 years ago, we had the presentation from workers' comp, the gentleman, he was a lawyer.
Carbone.
He's here.
Yeah.
Steve Carbone is not a lawyer.
And but all he said, explained to us was that any given day, any given hour, in any given courtroom, you have no clue which way that judge is gonna go.
That's exactly right.
And all he said to us, and what we've tried to do, like I said earlier, is our due diligence, trying to make sure of the safety of each student. So what we've done at Capital Region BOCES is I have not been able to place students where there's no workers' comp. We just shied away from that. We've also asked all employers to inform their carrier, you will have student interns here. Call your carrier, let them know you're going to have student interns here. There is no wage, but they're coming from a New York State approved program, and that what they'll be doing and when they'll be here. Let your carrier know. So far, just anecdotally, we have not had an employer come back to us and say, State Insurance Fund or whoever it was, there was no change in our compensation because it is an unpaid employee. Now, and again, that's what we've been doing through our due diligence in trying to place students in these areas.
It's a good way to do it. Go ahead.
I was going to suggest words along that line. This is not from my labor standards training. I have some peripheral information, and I'm wanting Mr. Ruff's response. If a person physically goes to a business location, there might be no workers' comp because the business might never have purchased it. There might be no workers' comp because there's no employees, just the owner. But theoretically, there's liability insurance. So if one of your students, with or without your permission or direction, goes to a place and either shadows or observes or helps out a tad bit and gets injured, first, I would think that the employer would notify their insurance company and either purchase workers' comp insurance that the provider acknowledges will cover this individual under these circumstances, or call Allstate or whoever, their liability carrier, and say, I'm going to have this person here. They're not really an employee because they're not that useful, and I'm not paying them anything, or it's a gray area. Can you put a rider on my insurance, or can you assure me that my liability insurance is going to cover this just the way they would cover a customer or a visitor trying to sell me something who slips on my floor? Just a thought out there, hopefully to be helpful.
Yes.
Mr. Ruff, thank you for the information this morning. Is it possible to get the actual court case numbers you were referring to? You don't have to do it now. I mean, I can stop and see.
I'll see if they're on here.
Yeah.
Yeah, one of them is, you want it now?
Yeah.
GO 1473, or 7538, that's the 2010 case. And the other one? Is number 67430. And that's an appellate division Supreme Court case. First one's a workers' comp case, the second one's an appellate division case decision.
Thank you.
Yes.
I have a question. All of my documentation for my unpaid internship students, I run a traditional one and a special ed one, says that the district is liable, is insuring the student. Do I need to change that?
No.
Well, the district is insuring
Yeah,
students anyway. But the question is, does the employer have to?
Right, do I need to change my documentation to indicate?
Not that I wouldn't think so, but I don't know for sure. That's a different area that I can cover.
Well, no, just about work, like, do I have to change my documentation that says that the student may be covered under?
If they get hurt at work, the parents of that student may want to pursue the workers' compensation.
Okay.
Besides whatever you're covering them by.
Okay.
These people had, these two interns, had health insurance from the university.
Right.
But it wasn't, one was covered, had to use it to pay the medical, the other got compensation.
Right, and I've had one student get hurt actually this year, and, the parent took him to the emergency room, and they used their health insurance, so it never became an issue for the student, even the district.
Well, yeah, and it could have been a disservice to the student if it was it could have been a root of compensation case.
I don't think.
Down the line.
Yeah.
In the future. Because the student would have got twice as much as, a minor gets double in benefits than.
Okay. But do I need to,
worker.
you don't know if I need to put any type of wording that says the student may be.
No. One of the worst cases I ever had was one of the first cases I ever had when I came to work at the Workers' Compensation Board. And it involved a farm worker, child, that was working on a dairy farm and got his arm torn off by a power takeoff. The kid was 8 years old. The farmer, who was not one of the best people you ever want to meet, said, definitely, I have no employees. It's just me and my son that work this farm. That kid was just visiting this farm. I don't know how he got his arm torn off. Thank God OSHA did an excellent job getting in there and investigating. This was out in western New York, down by the southern tier. Come to find out, this farm was big enough to supply milk to 3 different states. Also had a diner at the end of the road where he had the farm. He owned that too, but he didn't have any employees. Him and his son ran the whole thing. They were partners. They ran the whole thing. When OSHA came in, they found not only did they have an 8-year-old employee, that he had 12 other employees. and the oldest one's 14. That worked the farm. This guy was a bad apple. Had they given me the case 2 years before I got it, I would have went after him for a child abuse charge and tried to put him in jail. Unfortunately, the statute of limitations had run out on that particular thing, but we did finally win the case. 10 years later, we won the case. The child got his benefits doubled because he was 8 years old when it happened. But I got the farmer. We used the old Al Capone method. He's doing 15 years for tax evasion. Nobody gets away if we can really get him. Wow. Any other questions? Oh, you got it.
Well, no, I'm gonna cut it because we're cutting into their time now, so. But any questions that you have for Ed, you have my email contact, you can contact me, I'll connect you with Ed.
I got business cards here, I'll leave them on the table up there.
We'll be blowing up his emails, I'm sure. That information is available on the website for the 10
Good.
criteria for independent contractor, which is key to take them and print right now to show them.
Sure. I got one more quick thing to tell your students, no matter where they are, and they're working.
Put X's in.
If they go to work for anybody, they have the same, and they're getting paid. I don't care if it's illegal or illegal. If they have the same rights as anybody else to get hurt in the job, to file workers' compensation. A lot of kids are scared, they're afraid to lose their job if they turn over in unsafe acts and stuff like that. You've got to impress on them. You get hurt, you get medical attention, you file workers' compensation. Let us have the chance to get in there and see what the situation is, at least to find out what's going on, whether it's legal, not legal. Do we have to call in the Department of Labor? We have a program in Buffalo with OSHA that if a minor gets hurt on the job, they notify us, we're immediately in there. If we know about it, they don't, we notify them, they're in there. This started out as a pilot program, it's been going on for 20 years. Still a pilot program.
Thank you very much, Ed. We appreciate you coming.
Thank you very much.
Cheryl?
Oh.
Well, it sounds like it's less stress and stuff makes sense. We're still gonna keep them doing.
No, I was more.
Yeah, I'm just afraid that a lot of the folks here, I think they get too much into the legal aspects of it. And it's just a matter of, we put out a manual for work-based, coordinators. They just should follow that guidance, You can't go wrong with the guidance.
Next, we're going to have the topic integrating safety and health resources into our classrooms. We have 3 speakers. We have Susan McQuaid from NYCOSH. We have Jean Rodriguez from the Youth Construction Initiative Program. And Wendy Horn.
Yeah.
Oh, there she is. Okay, Wendy, come on up from NYSED. So I guess, we're starting with Susan? Yeah.
You can always live in fear.